Great.
Mayor, we are ready.
Good evening. I'd like to call the special call meeting of the Milton City Council for Wednesday, January 17th, 2024 to order. The city strongly recommends that you review tonight's agenda carefully, and if you wish to speak on any item on the agenda, then please bring your comment cards to the clerk as soon as possible. While the Milton rules allow a speaker to turn in their comment card up until the clerk calls the agenda item, once the agenda item is called, no more comment cards can be accepted. Will the city clerk please call the roll and make general announcements?
Good afternoon, Mayor and Council. I'll be happy to call roll for the January 17th, 2024 special called City Council meeting. I would like to remind those in attendance to please silence all cell phones at this time. Those attending the meeting who would like to make a public comment, you are required to complete a public comment card prior to the agenda item being called. All speakers will identify themselves with name, address, and organization before beginning their comment. If you are representing an organization, a notarized affidavit is required stating you have the authority to speak on behalf of that organization. Please review tonight's agenda. If you would like to make a public comment, please bring your comment cards to me now. Demonstration of any sort within the chamber is prohibited. Please refrain from any applause, booing, cheering, outburst, or dialogue with any person speaking. Anyone in violation will be asked to leave. As I call roll this evening, please confirm your attendance. Mayor Peyton Jamison.
Here.
Councilmember Andrea Veerhoff.
Here.
Councilmember Doug Haney.
Here.
Councilmember Juliette Johnson.
Here.
Councilmember Carol Cookerly.
Here.
Councilmember Jan Jacobus.
Present.
And Councilmember Phil Cranmer.
Here.
Mayor, you have a quorum. Would everyone please rise for the Pledge of Allegiance?
I pledge allegiance to the flag
Of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, next is the approval of the meeting agenda. Do I have a motion?
Mr. Mayor, make a motion that we approve the meeting agenda.
Second. Okay, I have a motion from Councilmember Verhoff and a second from Councilmember Kramer to approve the meeting agenda. All in favor, please say aye.
Aye.
Any opposed? That's unanimous. Next is public comment. Do we have any public comment?
We have none, Mayor.
Okay, I'll waive public comment and I'll ask the clerk to call the next item.
Mayor, that next item is, bear with me, new business for tonight. It's the City Council training to include open meetings and records, ethics overview, and discussion and/or possible direction regarding City Council internal rules of procedures and meeting efficiency. It is agenda item number 23020. Our city attorney, Mr. Ken Gerard.
Good evening, Mr. Mayor, members of the council. Ken Gerard here, the City of Milton attorney from Gerard and Davis. It's been an honor to be your city attorney for a long time. And to that extent, I will tell you, I've been doing this since 2007 in Milton, and I don't think I've ever stood here before. So this is new to me. I'm kind of enjoying this whole dais thing. Permission to move around the courtroom would be in order. And I'm going to do that. We've got a lot to cover tonight. I teach this course a lot. It's not Milton specific, but the notion of open records, open meetings, ethics, and meeting efficiency, I teach it a great deal. Typically, these are 6-hour courses. I can do a couple of days on this. So we're going to be going with light speed today to get through some of this. And the reality is we can do more of this if we need to. And if the council has questions or would like to dive into any particular subjects with greater depth, we can always do that. So without any further ado, and typically when I teach these, man, I love it when I get questions because I think that's when people learn. Is when they're actually engaged as opposed to just hearing me lecture. I don't know that we'll have a great deal of time at that, and I'm going to try to focus on what I really think is important. I've accumulated a lot of sort of historical institutional knowledge in Milton and hope I can bring some topics to bear that are, important to you. All right, so again, I only have an hour, so let's get going. I have provided you okay, back on. I've provided you a written materials that I'm going to be covering today. The only purpose of that is so you can take notes if you'd like to take some notes as we go forward. So let's go ahead and without any further ado, go. I have exactly 2 slides on some of the foundational documents of Milton, and I'm talking about your vision and sort of your statement of the mission of the city of Milton. Milton is a premier city where we strive to promote a high quality of life, create a strong sense of community and place, respect our rural heritage while guiding our future, and making Milton the best place to call home. Always nice to just sort of cover some foundational elements as we sort of are building a pyramid of good government today. Milton's mission, the City of Milton employees take responsibility to do what we can to provide the best quality of life to those who live, work, and play in Milton through excellent, responsive, and effective service. We work together to partner with our neighbors, meet their needs, and in doing so, strengthen Milton's cherished sense of community. And of course, I don't have to say it, but the City Council is integral to fulfilling that mission and to establishing the policies that allow the employees to do exactly what your website articulates to its citizens that you intend to do. And it would also be fair for me to say that compliance with state law that guides sort of the minimum foundational requirements of how local governments operate is critical to that. And I'm talking about the Open Meetings Act, which we will spend a few minutes on. The Open Records Act, we will spend less time on because that's handled by your professional staff in conjunction with my office. We're going to talk a little bit about ethics. We may actually come back and do some additional ethics training later in the year, not because you have any particular need for it, but because all local government officials should hear it and have an opportunity to ask questions about it. And then we will spend probably the most time today talking about meeting efficiency and some of the byproducts of literally a retreat we had in spring of 2023. We had a retreat, we heard some feedback from the council, and so we distilled that into a list of points that we might be able to bring to bear to make the City of Milton meetings a better experience for everybody, to include, importantly, the citizens and taxpayers of your jurisdiction. Efficiency is very important. Making people have a meaningful meeting experience, watching the City of Milton's business get accomplished is critical. And we want to set the table as best we can that people can come, they can engage their government in a meaningful way, and then they can get home and otherwise partake of whatever duties they have to do in the evening. So we'll talk about that. Without any further ado, let's talk about open meetings. To the new council members, welcome. You have officially caught the bus. And having caught the bus, you are now subject to the Open Meetings Act, whereas you weren't on December 31st. On January 1st, 2024, you were. And that carries with it all sorts of responsibilities. And so I want to talk to you about the Open Meetings Act. The Open Meetings Act and the Open Records Act basically are different sides of the same coin. They are both remedial acts that were enacted by the General Assembly to promote transparency and confidence in government. That's, if you were to distill it to its most foundational, that's the key. The idea is that there's a reason that they're colloquially called the Sunshine Law, because of the idea that government is best undertaken in the sunlight, that the idea of dark, hidden rooms where decisions are made in front of a swinging incandescent light, those days are over. That our citizens derive their best opportunity to have confidence in their government when they can see the actions of the actual decision makers making those decisions, and they have ready access to the documents that serve as a lot of the justification for those decisions, whether it's minutes, whether it's contracts, whether it's plats, whatever those documents may be. So they work very seamlessly together. The Open Records and Open Meetings Act have been Georgia law for some time. The last significant rewrite I was involved in was in 2012. So it's one of those acts where it's rarely opened up. When it is, the changes tend to be significant, then it's closed for quite a while. So it's a little behind the times, but some of the technological advances that have occurred, the Open Meetings Act uniquely is struggling to catch up with them. But I think the General Assembly will eventually act. What organizations are covered? I would submit to you that, first of all, the council obviously is, but also a lot of your inferior organizations. And when I say inferior, I never mean that to be diminutive. I'm just talking about entities that aren't you. You are the highest policymaking group in the city, but you have a planning commission, you have a DRB, you have a BZA, you have these inferior entities. They're also subject to the Open Meetings Act. So all of these sort of functional components have to be transparent, all of them. All right, so with respect to open meetings, and I'm going to get into a little bit more of the intricacies, but if there is an open meeting as governed by the Act, who gets to participate? And the answer, of course, as you would expect, is the public at all times. The Open Meetings Act is very specific that the public, to include the traditional press, but also I would include the non-traditional press, to include any citizen, has the right to video and audio record your meetings. You may say, well, our meetings are audio and video recorded anyway, and the law would say it doesn't matter. They have the right to come in and they have the right to bring a cell phone in. And if they want to video you while you're otherwise being videoed by the camera behind us, they have the right to do that. Citizens don't have a right to obstruct the meetings with their camera, but they have the right to video should they choose to. We have the right to adopt reasonable rules and restrictions with respect to the conduct of our meetings, and we have done that. In fact, the council has its own internal set of rules, and we're going to be talking about those a little bit today when we get into the efficiency components of the training. All right, so let's get down to brass tacks. What is a meeting from the purpose of the act? And the answer is a meeting of the city council is any time a quorum of the members of the city council come together, at which, here's the key in the first bullet, at which any official business, policy, or public matter of the agency is formulated, presented, discussed, or voted upon. Note that the act of voting does not make a meeting. It can be any meeting where you are even hearing presentations about matters involving city business. What is a quorum? In Milton, a quorum is 4 of the council members, to include the mayor. The mayor is considered for purposes of a quorum as if any other council member. So 4 of you together is a quorum, 3 is not a quorum. Okay, so that's very critical. Second bullet point, the gathering, what is a meeting? The gathering of a quorum of any committee of the members of the governing body. So in other words, if you all took official action to create a committee, let's say of 3 of you, to go out and, I don't know, review park and rec initiatives, and you created this committee of 3 council members, well, then 2 of those council members would be a quorum for purposes of that subcommittee. The idea being is that subcommittees of a governing body are subject to the act as well, because we all know how subcommittees work. They go off and do their work. They come back, they bring a recommendation to you. You all then agree to whatever recommendation they make. The law said, no, wait a second. We want to watch that subcommittee work. We don't want that work to go on in the darkness. So a subcommittee of your own members is subject to the act. What if you were to create a subcommittee of lay citizens? What if you just put together a subcommittee of, let's say, 2 council members and 2 lay citizens, and you created that committee too would be subject to the act. So you get the idea. They're trying to cover everything. They don't want any of the business of the jurisdiction not covered by the act. Let's keep going. I've defined for you now what a meeting is, and I meant what I said. It's broad. And if you ever have a question, any of you, as to whether or not what you're about to do constitutes a meeting, then call me. Your clerk is always good to call me and say, look, there's going to be this organization and a quorum of them may assemble. Do we need to, prefatory and prophylactically run a legal ad and an agenda? And we'll work together to make sure that I take care of that. So if you have a question, that's what the city attorney is for, is to answer those questions. And if I get it wrong, it's on me, not you. So let's make sure to take advantage of that with respect to what a meeting is. If it's 4 of you getting together, though, I'm very likely going to tell you either don't do it, don't go to the steakhouse and talk about Falcons football. I don't care if you think you're not going to discuss city business at all, or I'm going to say, let's go ahead and run that notice and agenda and make it official. And that just takes away all doubt. I don't have to tell you, but we live in an age where everybody's got a smartphone strapped to their waist, and everybody's got video cameras and all sorts of things. And I don't want to be explaining to the Attorney General why that dinner at the steakhouse was not a meeting. I would just prefer it not happen at all. Okay, so if 4 of you are getting together, give me a call. All right. What is not a meeting? The act, and particularly in 2012, this didn't used to be in the act, but in 2012, it was modified to now specifically provide when it is not a meeting. So understand, this is talking about when a quorum of you gather, but it's not a meeting under the act. Number 1, you have the right as a quorum to make physical inspections of the property under your jurisdiction. Hypothetical, The city manager calls you and said, look, I'd like us to get into a bus together and I would like us to tour and go eyeball every city park in the city of Milton. Would that be a meeting? No. You would be conducting inspections of properties that are under your jurisdictional authority. No press needs to be there, no notice, no agenda. It's not a meeting. Now, when you're in that bus driving around looking park property, you can't talk about the next zoning coming up on the agenda, right? You have to stay true to the reason that afforded you the exemption. So the inspection of properties under the jurisdiction of the government can be accomplished without calling a meeting. Number two, attending statewide multi-jurisdictional or regional training. Many of you may go to the GMA annual conference in Savannah or wherever it is. Many of you may go to new council member training, all sorts of training. I do a lot of them mainly for counties, some for cities. What I can tell you is those training opportunities, you may be literally sitting at a circular table getting trained with a full quorum of your council. It's not a meeting. So the General Assembly has said, look, these are important opportunities for training. There's not a meeting there. Again, the same rules apply. If you're at that training seminar, don't use that to talk about the latest zoning that's coming your way. You have to stay true to the reason that afforded you the exemption from the act. So inspection of properties, now multi-jurisdictional training. Number three, meeting with officials of the legislative or executive branches of the state or federal government at their offices. Let me give you an example. Again, this is not a meeting. It's beginning of the legislative session. You want to go meet with your delegation to the General Assembly to talk about initiatives that you would like to see carried forward in the legislative session for the city of Milton. You have the right, as a quorum, the full council could go down to the Gold Dome, and you could sit in the office of one of our state reps or state senators, and you could meet as a full quorum with those representatives and to talk about City of Milton initiatives and what you'd like to see advanced in the legislative session. That's not a meeting. No press, no agenda, no public, no nothing. Okay. So again, you have to stay true to the reason. You have to talk about, statewide initiatives that you'd like to see advanced that would benefit the city of Milton, but you can do that. So these are, again, express exemptions under the Open Meetings Act. The Open Meetings Act is so granular that you have the right to travel to these various places. So when you're doing that tour of park properties and you're in a van together, you're at a quorum, right? Well, the act says, yeah, you can travel to the various park properties, and that's not a violation of the act. If you go together and get in a van and travel down to the Gold Dome together to go meet with your state representatives, can you do that? Yes. That's 30 minutes in a van together, and you can do that. Now, should you avoid discussing city business otherwise? Yes. And so I always get this question, can we drive down to Savannah together? Yes. And if you want to drive 5 hours with each other's company, that's great. I have a feeling, though, you may quickly run out of things to talk about that don't involve city business. So my recommendation is don't do it. But you have the right to, because that's expressly set forth in the act. And finally, the last bullet point, if you happen to attend social, ceremonial, civic, or religious events, and a quorum of you happen to assemble, that's not a meeting either. So a social event, that could be just a dinner party. A ceremonial event could be the opening of the new store with the big, extended scissors and the big red tape. That's a ceremonial event. A civic event might be a local chamber function, and you all happen to be there as a quorum. A religious event, I don't think that needs any further explanation. The idea is those events uniquely shouldn't involve you discussing city business. They should involve you doing the things that allowed you to be there. Yeah.
So let's expand on that. So any one of us could have a party where we're inviting a lot of people from the community and invite our colleagues here on the dais. And as long as we're not talking city business and it's not just a party of us.
Right.
That's it.
That's
fine.
correct.
Okay.
Yeah, that's right. I mean, that's such a good point. And if I was to tell you what the most common of these that's implicated, it's the social event, it's the party, it's the Christmas party, and there's a lot of people invited. And my instruction to you in those situations is, of course, you can come. It's very unlikely you would discuss city business. I would only say there will be a lot of people there. They may be watching you, knowing that you are, in fact, a city council member. So don't huddle. Don't huddle together in the corner and the four of you sort of, limit, access. Just engage like the party. But yes,
thank
Councilmember
you.
Cookley, that's right. You do have the right to do that. And that is exactly why that exemption was put into the act.
Can I also ask, I've had questions, and that will also apply to the upcoming State of the City and any promotional ceremonies that we have. I've had that question asked to me.
Yeah, so the state of the city to me would be in the nature of a civic event that is obviously hosted by the city council, but the reality is that's for the community to come and hear about the state of the city. So that's a civic event. My expectation would be that most, if not all of you would be there, and the same rules would apply. You have the right to attend, you have the right to participate, but I would, for instance, I wouldn't all sit together at the same seat. Most of you would probably sit different than that. I get this question a lot. I mean, I've got counties that have a state of the county event. I've got sometimes they have a chamber event where all of the elected officials come. And it's to do that sort of typical thing. It's a ceremonial or civic event that the entire community is invited to. And therefore, it doesn't hold the specter of sort of backdoor politics. It's very public. It's very transparent.
Thank you.
Any other questions on that? Again, I am going a little faster than I'm used to, so please forgive me, but it's already 20 after, so I gotta keep cooking. I've already gone over some of this. I'm gonna skip ahead. Situations to watch. I just always like to make these sort of cautionary instructions. A lot of people have this idea that if you're at a seminar or a work session or a retreat, these rules don't apply. And the answer is there's no such thing as sort of a meeting. It's a very binary calculus. You're either in a meeting and all of the trappings of a meeting accompany you, or you're not. So there's nothing about leaving the jurisdiction that makes it less a meeting. There's nothing about calling it a seminar that makes it less of a meeting. There's nothing about calling it a retreat that makes it less of a meeting. A meeting is a meeting is a meeting is a meeting. So those are situations to watch, and certainly pre-meeting meetings, the very innocent, you get here early, 4 of you gather around and you begin to chit chat. We're just about to have a meeting, but not yet open yet. The public's not yet invited. We're just casually talking. Just be aware of those situations. We want to avoid even sort of the appearance of engaging in the official business of the city of Milton without the public being here to watch and see what we're doing. And so we'll keep going. With respect to these next topics on notice and making the public aware, I will tell you, you've got a phenomenal clerk and we work closely together, so you don't need to really worry about this. I'm just going to cover these in sort of broad themes. Number one, you have different sorts of meetings. And I'm not backtracking. A meeting is a meeting is a meeting is a meeting, but they do have different notice requirements. For instance, the meeting that you're about to be in a few minutes is going to be a regular meeting. That is the regular 2 times a month meeting that the city of Milton has, where you take votes and engage in the official business of the city. Now, normally they're on a Monday because of the holiday. I know it's on a Wednesday, but you get the idea. And those are set in place. They are scheduled a year in advance. In fact, I suspect, Tammy can run the notice of those one time on January 1st, and you know exactly the schedule of all the regular meetings of the city of Milton for the entire calendar year, okay? Then you will have another class of regular meetings called work sessions. And those are meetings where we typically don't take votes. We may go into executive session, we may not. We have the right to, but those are a different species of meeting. And then you have meetings like special called meetings, which are what we're in right now. So the notices are all different. For instance, for a regular meeting, you have to publish a notice 7 days in advance. For your typical special meeting, you have to publish a notice at least 24 hours in advance. Now, there is an accommodation for even a meeting with less than 24 hours notice, but it has to be caused by emergency situations or conditions. And when you open that meeting, the chief executive has to literally put onto the record what special emergency situation required there to be a meeting with less than 24 hours notice. So it is an unusual situation. You'll ever have a meeting without 24 hours notice. Typically, it's either going to be a regular meeting, a duly scheduled work session, or some sort of a special called meeting with greater than 24 hours notice. Okay, those just, again, I don't really bog us down into the intricacies of what needs to be in the notice. Tammy's got that. We work on anytime there's an unusual situation. But I just kind of wanted to make you aware that's the sort of way that goes. There's sort of 3 classes of notice. That's what I wanted to make you aware of. I'm going to move on now, again, picking up speed to agendas. So think of meetings and the way these notices and agendas work is sort of a function of due process. All right. You've all heard due process of law, and it's embodied in the 14th Amendment to the U.S. Constitution. But the notice of due process basically says that we need to give certain individuals, whether it's our citizens, whether it's defendants in court trials, whatever it may be, notice and an opportunity to participate. All right. So if it's in the meeting vernacular, if I'm a citizen, how do I participate if I don't, number one, know you're having a meeting? That's the notice. That's that little notice that Tammy has to provide. But then for me to decide if I want to participate, I need something else. What do I need? I need an agenda, because that allows me to decide if I want to participate in that meeting or not. And that's why there's a 2-step process with respect to calling a meeting. You have to publish that notice. There's going to be an opportunity for your government to get together. And the separate document is the agenda. Here's what we're going to talk about. And that's a function of due process. With respect to when you have to publish that agenda, the normal rule, and this is obviously written by lawyers, it is as soon as is reasonably practicable before the meeting. You define that. I'm not sure what that means. But here's what I tell when I'm teaching this. I think that means between 3 and 5 days before the actual meeting. You publish your agenda too far in advance of the meeting, then you're going to miss a lot of items you really needed to have talked about at that meeting. If you publish it too close to the actual day of the meeting, then your citizens don't have a reasonable opportunity to decide if they want to participate. I think 3 to 5 days is about the sweet spot. Okay. And as an aside, the agenda should include every subject matter that we reasonably believe will be or needs to be discussed. Okay. So you can't omit an item off the agenda in hopes of not allowing people to know you're going to have this discussion and then throw it on the agenda at the meeting in an attempt to game the system. So I raise that to you because of the statutory language I have in front of you on your screen, 5014-1E1. That has been in place for a while. And what it says is just because we don't include an item on the published agenda, if an item becomes, quote, necessary to address during the course of a meeting, that does not preclude us adding it to the agenda and hearing it that evening. But it truly has to be something that sort of cropped up or became live between when the meeting was published and the actual night of the meeting. Somewhere between that temporal time span, that's when it needed to become effective. It couldn't be, yeah, we needed to put this on the agenda, but I didn't want to put it on because, people would come and be upset about it. So we waited. You can't do that. And I have experienced some litigation in other jurisdictions, not Milton, where that was raised, that it was sort of an attempt to game the system by leaving an item off the agenda. So we won't do that. We don't do that here in Milton, I know, but I just wanted to raise that to you. We have every right, however, in good faith, if it's done in good faith, to add items the night of the agenda that become necessary or have some time sensitivity to them to consider. Meeting summaries, again, just things you may want to know this, you may not have known this, but every agency that's subject to the Open Meetings Act, after the meeting ends, the clerk or whoever is in charge of doing this has to provide what's called a meeting summary within 48 hours. Wow, that's quick. And the reason for these meeting summaries, probably a little bit archaic at this point, but this was done when governments would literally meet once a month and they'd take their action. And remember, they'd prepare the minutes, but the minutes wouldn't be adopted till that next meeting a month later. And so your typical citizen would have no idea if they didn't attend the meeting. Wonder what happened at that meeting. So meeting summaries were invoked, and that was a 48-hour snapshot only to know what action had been taken at that meeting. Now, in the days where governments are now putting their meetings online in video and all this robust access we have, you can go back to watch meetings from 10, 15 years ago. The notion of agenda summaries or meeting summaries, you could debate whether that's needed anymore, but it's still a law. So we have to do that thing within 48 hours. Tammy's got to crank out what's called, you call them action minutes. Is that what you call them?
I do.
Yeah, action minutes. And the reason it's got that lingo attached to it is because that's the actual action that the council took. It's sort of a streamlined snapshot of minutes until the real minutes are approved. That's meeting summaries. And of course, the minutes, you understand that. The minutes are the official record of the legislative and policy initiatives of the city of Milton. Minutes are so important in Georgia that from a record retention perspective, they have permanent retention. You can never delete your minutes, not ever, hard stop. No. In fact, in a courtroom, if I'm trying to establish or prove what this council did, I'm entering a certified copy of your minutes. That is the best evidence of what you've done. So that's why we take a lot of time to prepare them, although I think your clerk does, and that's why you have to approve them. I will tell you, just a practice pointer, if you're ever reviewing your minutes of a meeting that has already occurred and you remember something differently, not something you wish it occurred, but in other words, something that factually did occur that you're like, these minutes don't reflect what actually happened, bring that to our attention. That's the reason you approve them. And I would much rather you say, Ken or Tammy or Steve or Stacy, these minutes, they're not actually capturing what occurred. Then we can correct them, assuming we agree, and correct them before you approve them. So it's not just a rubber stamp. I mean, when you're approving those minutes, the expectation is we all agree that is the official proclamation of what occurred at that meeting. Real quick, participation in meetings. Can you participate telephonically or by video conference? And the answer is yes, you may. You have seen us do that a couple of times here. Some or all of you have. Absent an emergency condition or a medical condition that will elicit a doctor's note, you can do it twice a year. And I will tell you, there are some rumblings to try to increase that allotment to 6 times a year this session. I will tell you, COVID changed everything. And one of the things that COVID changed was the idea that we do a pretty good job now with teleconference meetings and the ability to simultaneously broadcast people attending remote. So there might be an opportunity for that two times a year to go to 6. Now, I've been a part of a government where we had a member that had, due to medical issues, had a doctor's note that this board member was unable to attend due to just a suppressed immunity situation. And that member participated telephonically for half a year. So the law contemplates that there could be health situations that should accommodate more. Don't read all that, a lot of text there. The only reason I put that on there was that's also language that says that if there is also a true emergency condition, think a weather event, something like that, that we can go ahead and do true cyber meetings. And of course, anybody who lived through COVID remembers that everybody was doing cyber meetings. And in fact, some governments in the metro did not convert back to real life meetings long after they should have come back to real life meetings, because those cyber meetings were so convenient. So every meeting sort of looked like a Brady Bunch, introductory screen. Did I just date myself? I probably did, but a Brady Bunch introductory screen. And we would just have our meetings by cyber telecast. The only restriction is it has to be an emergency condition. I think COVID certainly qualified for that. And number 2 is that whatever is occurring has to be simultaneously broadcast such that citizens can watch it in real time. And of course, that technology is reasonably new. That didn't exist probably 20 years, 15 years ago, but now we have it and can do that fairly efficiently. And so it was a very effective way for us to continue to meet during the pandemic. Okay, executive session. So that's closed, right? So it's remarkable, but governments have the ability to literally engage in business where the public is purposely allowed or not permitted to observe it. And there are very good public policy reasons for that. And this is sort of a balancing test. Why, I've been here prattling on about transparency and openness and openness and openness. And now I'm telling you, we have the right to go into executive session to keep the public out. General Assembly's done a pretty good job of balancing these interests. So let's talk about the why. One of the reasons we can go into executive session is to talk about potential and or actual litigation. And the rationale for that is, of course, the attorney-client privilege. If we need to, or you need to hear from your attorney, whether it's me or if it's an insurance retained attorney that's not me, you should be able to have that discussion without the public being able to observe it. Probably I'm giving you information with respect to liabilities the city may face. And if the public heard that, that would mean the other side, the opposite party, could hear that as well in the litigation. And therefore, that could impact the city's liability posture. That's a reasonable basis for us to be able to go into executive session. We can also go into executive session. These second and third bullet points on your slide, you may not have known that. And that's a fairly recent modification to the Open Meetings Act, but it's to allow us to talk about cybersecurity plans. I don't have to tell you, but we live in an age of identity theft, of hacking, of all sorts of different intrusions into our cyber security. We have governments this year that have had ransomware installed, where there have been vulnerabilities in their system. And I believe, don't quote me on this, but I'm fairly comfortable that there have been even some governments that have had to pay those ransoms just because of the insidiousness of what those individuals and the information they're able to get. So you do have a right to go into executive session, talk about your cybersecurity plans from a public policy perspective. Why would that be so? Because if the bad guys can hear our cybersecurity plans and our vulnerabilities, then they could exploit them. That's why. Continuing on executive session, we have the right to discuss acquisition, leasing, and disposition of property in executive session. Okay, and I think those are, whenever you hear the mayor or the motion being made of, I move to go into executive session for purposes of litigation, land acquisition, and personnel, there's a reason that we have to say that. Okay, that's not just some rote language that me or Tammy cooked up. The statute actually says when you go into executive session, there is a requirement that there be an open session that has to be duly assembled. So you have to start an open session. Then there has to be a motion made where you identify the reasons you're going into executive session. And those three reasons are land acquisition, litigation, and personnel. If it was a cybersecurity plan, then I would ask the mayor, include cybersecurity plan in your motion, because if we don't identify it in the motion, we can't talk about it in the executive session. We have to identify the specific variety of topic that we're discussing in executive session. Now, we typically identify all of them because candidly, sometimes we'll be in executive session. We may have gone in to talk about litigation, and one of you may want to talk about a personnel topic very quickly, or one of you may want to talk about a land acquisition topic very quickly. And we have to let the citizens know it could be all three topics, because whatever we go in there on, that's all we can talk about. So that's typically why we talk about the three. There are at least two additional categories of topics that we could go into executive session to talk about. One would be the cybersecurity plans I've already referenced. And then there's another very nuanced allowance that says, wait for it, that if there is a document that is not subject to release under the Open Records Act and can only reasonably be discussed, if you discuss it out loud, you're going to reveal the contents of it, you can go into executive session to discuss it. And so when I'm teaching this, what I'll tell people is what document might that be that would not be subject to the Open Records Act, and that any discussion of it might reveal its contents. Counties have to do this, cities don't, but one of them is a courthouse security plan. Cities don't have to do those, but counties do. They have to prepare and fund courthouse security plans, and a courthouse security plan is a lot like a cybersecurity plan. If you talk about the courthouse security plan, you're revealing the vulnerabilities of the courthouse. So you can talk about a county courthouse security plan, and executive session. But the typical three are what you're comfortable with. Land acquisition to include disposition, personnel, and litigation. And that includes, litigation includes potential litigation, and potential litigation can even mean those situations where the city may want to bring litigation. And the person that needs to make that call is me as your city attorney. And the only reason I will allow us to go into executive session to talk about potential litigation, if it's a case that we are thinking about bringing, is if I believe in good faith, we are really thinking about bringing it. And if we are, you have the right to go into executive session, and you have the right to hear your lawyer tell you about it and talk about what I think the good, the bad, the ugly is of a potential case. With respect to litigation only, you cannot go into executive session without your city attorney there, because the only reason you get to go into executive session to talk about litigation is because of the attorney-client privilege. Interestingly, the other two topics, land acquisition and personnel, the city attorney doesn't necessarily have to be there. You can go in to talk about those topics without me. That's unusual. I'm involved in most of the executive sessions, and whenever I teach on this, I recommend that the county attorney or the city attorney go into executive session, if for no other reason than I can be responsible for saying, I think we're drifting and we need to keep focused back on the topic. And I think that's part of my job, is to do that. I'm going so fast, and y'all have to forgive me, but I'm just trying to be mindful of our time. Let's keep going a little bit. I'm gonna skip a little bit of our executive session. Just ask me. I do want to mention this just because it drives this point home. If you catch up with me, you'll see the slide I'm on. I'm at the very end, talking about the consequences for violating the Open Meetings Act. And I want to raise a recent occurrence in Milton and how we handled it. And this involves an allegation that there was a violation of the Open Meetings Act in the fall, I believe, with respect to this event that occurred at, I think, the Avalon. And that Open Meetings Act complaint came in. The Attorney General did what I have certainly been on the other end of before. The Attorney General basically asked for the city of Milton to provide its position with respect to what occurred, September 18th of 2023. I hope all of you are familiar with what I'm talking about. To the new council members, if you're not, forgive me. I can get you all the background documents so you can read about it in your own. I'm not going to go through it in detail, except to say that it was a technical violation of the act. I believe it was in good faith, which is what I told the Attorney General, but it wasn't perfect, and it had to do with the agenda and the moving of the space from one meeting space to a different one. Again, I felt it was something that was done in good faith, and we took and went to a lot of effort to try and remediate that situation, to include adopting minutes and to include allowing various council members who wanted to provide narratives with respect to what they felt had occurred at that meeting on September 18th of 2023. And we bundled all that together, provided it to the Attorney General, and included language that I would provide a teaching opportunity on open meetings, which I'm doing today, and I will continue to do for you just to make sure that we don't miss this. But it is important, and I wanted you to see this. This is basically the primary response of the Attorney General, where she makes a point, and it's a good one. And she says, look, I appreciate all the after-the-fact things that you did to sort of remediate and restore trust in the citizens. That's great. But the reality is part of the Open Meetings Act is contemporaneously the citizens being contemporaneously able to watch. In other words, they don't get to hear about it later, they get to see it in real time. And so she's making the point that as much effort as you went into to sort of provide an after the fact narrative, the whole point of the act is for them to see a real time observance of their government in action. So, and it's a point I can't challenge. She's right. But to your credit, you all have asked me to come and do this training. I've done it. I will commit to you as your city attorney to be even more diligent to make sure that we stay on the straight and narrow. I know that is everybody's objective. I know that, having spoken to most of you, and the new ones I will get to. But I'm very comfortable that we will do very well, and that this city is committed to transparency. Very comfortable with that. I'm not going to speak about open records. I'm just not. Understand that you have got an amazing staff that are handling the Open Records Act. When they have questions, they will talk to me about them. And my office has several different attorneys dedicated to open records. The only thing I want to make sure that you understand in open records, and I'm kind of going to just not go to my slides, is that your communications are subject to the Open Records Act. Now, there's easy communications, and that is your emails that are done with using your City of Milton email suffix. That's easy. Those are all captured on the City of Milton servers. I never have any problem getting those. I don't. And I'm not suggesting I have any problem getting any, but I just want to alert you that some of you may be walking around with multiple devices. You may have a City of Milton issued phone, and if it's taxpayer paid for, then the emails, basically the entire contents of that phone are subject to the Open Records Act. Any documents that you generate are subject to the act. Text messages on your city phone, also subject to the act. Let's talk about your private devices. You may have a private cell phone. If you're getting city communications on your private devices, my recommendation to you is to sort of train your constituents to use your city-issued device. Move them that way. I don't want you having to make, every time an Open Records Act request comes in, I don't want you having to search your private device. Keep a nice level of segregation between your private device and your city paid-for device. If you maybe even inadvertently engage in city business on your private phone, just be mindful of that. If we get a request, I may have to ask you, or Tammy may have to ask you for those text messages, for those emails on your private device. You'll have to look for them. I will tell you, I've been doing this a long time, asking elected officials to provide their data for a long time. I have no choice but to rely on the honor system. So when I ask you, you have to look for it. Unless you want me to look for it, I'll be happy to get your device and look for it. But if you want to look for it, but I'm going to take you at your word. If you say there's no documents there, I'm telling Tammy, there's no documents there. We're moving on. So just be mindful of that. And again, you may have a ton of questions about open records, and you can engage me individually. I'll be happy to go through this in more detail. I can't believe I'm missing ethics. I've got to skip past ethics because I've got to get you to meeting efficiency in the 10 minutes that I have left. And Mr. Mayor, I apologize, and we can come back
Ken, we can always
and do this. We can do more of the
We can add
ethics.
a work session later.
So I want to talk to you. I'm skipping forward now. I'll try to find it on the slide so you're not having to guess where I am, but I'm unfortunately having to skip quite a bit. All right. We're going to meeting efficiency, and I want to tell you about the retreat we had back in the spring of 2023. Now, the city manager was kind enough to let me sort of put this together, the retreat documentation. And I made a series of recommendations based upon how I see City of Milton's meetings go. And I want to walk you through those. And at the end of this meeting, in just a few minutes, I'm not going to be asking you for a vote today, but I would like to check your temperature on whether you would like me to put my recommendations into a product that I could tee up to you for an actual vote. Okay, and let me explain what they are. And again, just forgive me. I really thought I had, gotten this to a good place. All right. First of all, number one. Let me do one more. Okay, here we go. First of all, number one, the things that I recommended at that retreat, 6 of these were at that retreat. Right now, when we have our consent agenda before every meeting, our poor clerk is having to read every item of the consent agenda before you adopt it. And there's a reason for that. It's in our rules. It's unnecessary. We have a published agenda. Our citizens can read through the agenda and look at the items that are read on the consent agenda. I'm not personally aware of other governments that read every item on the consent agenda before they adopt them. And I would respectfully propose we strike that language out and just allow the consent agenda to stand as any other published agenda item, and we adopt the consent agenda. Our citizens can read it for themselves should they want to. That's number one. Number two, public comment. City of Milton has a formal public comment opportunity that it provides at the beginning of every meeting. You then have zoning hearings. You then have public hearings, and then you ask for public comment at every agenda item. I would respectfully recommend that we discontinue a public hearing opportunity or a public comment opportunity at every agenda item. I would recommend we convert to having a public comment section at the beginning of the meeting and maybe a public comment section between new business and unfinished business. That's two robust opportunities for citizens to come and talk. But having a public comment section before every agenda item does a couple of things. Number one, it confuses whether it's a public hearing versus whether it's public comment. That's number one. Number two, in some items, there has already been public comment or public hearings leading up to that item being on the agenda that evening. And it further elongates the ability of the city to go ahead and just make a decision. Number three, there are people in your gallery who are here because they have business to get to. They want to see something that's important to them, something they may have on the agenda. And sometimes the City of Milton's meetings can elongate to the point that it's 8 o'clock before we're actually getting to these substantive agenda items or substantively making its way through those items. And that can be very disenfranchising. If you've got kids at home, you got to get to bed, you got school the next day, staying at a Milton meeting till 9 or 10 o'clock at night can be challenging from a participation perspective. Public comments, having two robust opportunities for public comment is very typical. That's what most governments do. And I would recommend that you all think strongly about shutting down the notion of public comment for every agenda item. Okay. Number three, have a uniform public comment timing opportunity. I'm going to talk to you about that in just a second, but our timing for our public comments versus our zoning public hearings versus our regular public hearings versus our work, they're all over the place and they're difficult to keep up with. They're difficult for me to keep up with the various time divinations that we have. We need to have a public hearing time allotment, and then we need to have a public comment time allotment, and that's it, just two. And for typical public hearings, we ought to just follow the zoning procedures law. That's a nice baseline. It's 10 minutes. It's 10 minutes. That's easy. It's easy to keep up with. And then for public comments, I'll make a recommendation on that as well. Number four, how are we doing? We have public hearings, and I don't know if you've seen this or not, but we'll have a public hearing and then we'll have the actual vote on the public hearing item later in a different part of the agenda. We need to collapse that. You just need to have the public hearing. After the public hearing's over, we can go ahead and take the vote. There's no reason to put it as a separate item somewhere later, just so we can call the item again and say, yeah, we had the public comment an hour and a half ago, or the public hearing an hour and a half ago. We need to have the public hearing, and we need to go ahead and take the vote right then. Put that out on the bed. It's fresh. You just had a public hearing on it. You know exactly what you're thinking. Having that decision another hour and a half later is just an opportunity for confusion. That's what it is. Number five, we have a public hearing agenda, and then we have a zoning agenda. We just need to have a public hearing agenda. Zoning items can be under the public hearing agenda. Alcohol code issues can be under the public hearing agenda. We just need to have a public hearing agenda. There's no need to bifurcate it into a public hearing and a zoning agenda. It's just a public hearing agenda. That's perfectly fine. Number six, you all have a huge rule about reading emails into the record. And it involves the clerk assembling these emails, and then sometimes she's got to make a decision as to whether somebody had a bona fide reason they can't come up and speak, or whether they have a bona fide reason they're not in attendance that evening. You know, look, if we want emails to be included in the record on a topic, no problem with that. But if people want to come and speak and address and be on the record at a public hearing, they need to attend. They need to attend the meeting. They need to walk up and they did make their public comment. And I think we need to move away from this notion of people being able to just email in a public comment and then put this burden on our clerk to decide if they have a bona fide or not bona fide reason of being in attendance, or whether that should otherwise make it into the record. If you wanted to nuance this and say, look, if you guys want to send in, citizens want to send in an email, they'll be part of the record, that's fine, but I don't think we need to keep reading these into the record. Public comment should be public comment, should be public comment. It should be something verbal where they are confronting and addressing their government in person. Number 7, we have 2 regular meetings each month, and we have traditionally had 2 work sessions each month.
Really?
Regular meetings are
Just one,
work
just
session.
one work session.
Just one work session?
Yeah.
But on a separate time, but on a separate day.
Correct,
Right.
correct.
So we really need to probably think about, we could put that work session before one of our regular meetings, maybe an hour before, 2 hours, whatever the amount of time we need. But there might be a way to sort of take one date away from you a week or a month that you're having to otherwise figure out to make that available for a meeting. I think that might make your lives easier. There's nothing in the charter that requires us to have that work session at any particular time. In fact, there's nothing in the charter that talks about a work session at all. This is totally in your wheelhouse. So it might be very effective if we continue to have those 2 regular meetings, put that work session right before one of those regular meetings, and thereby freeing up a little bit of your time and candidly allowing citizens that only want to have to come out once to see that work session and regular meeting, it's only one trip to City Hall as opposed to multiple. So again, just something to think about. Seems like that might make some time. And then staff reports on the agenda. Again, this is completely up to you, and you're going to have to make the call on this. But certainly I have seen great reports. But again, we start getting into hour 2 of the meeting before we're hitting the first agenda item. Staff reports providing valuable information to the council. And if citizens see those staff reports on the agenda and they want to stay and watch those reports, great. But I think putting them at the beginning of the agenda sort of forces the citizens that have agenda item business to sit there and listen to those, whereas therefore their agenda item just doesn't get done until that's completed. So just, again, something you might want to think about. It's all about trying to make, your citizens have the most meaningful meeting experience possible. Because again, the whole objective of open meetings is really more about the citizens being able to engage their government than necessarily about us. And so if we're able to make maybe their experience a little more meaningful, and maybe they can get home and do what they need to do if they have sat through that part of the meeting they want to sit through, great. We've done good service. So those 8 topics, I have more on those, but I don't have time on those.
Yeah, Ken, let's discuss this maybe at another future council meeting so
Okay.
we can kind of have some discussion and debate back and forth and see what's best and move forward.
And Mr. Mayor, if it's okay, I completely agree with that. Maybe at the next work session where we present these items, we could maybe just focus on this slide and walk through these again. And that could be almost the sort of
Perfect.
agenda. And then you all could tell me, like this one, don't like this one, et cetera.
Yeah, perfect.
All right.
Thank you,
Thank
Ken.
you all
Appreciate
very
it. It was
much.
very
Counselor,
informative.
thank you.
Okay. I'm going to, that will conclude our special call meeting. Do I have a motion to adjourn?
I'll motion to adjourn the special call meeting.
Second.
Okay, I have a motion from Councilor Haney and a second from Councilor Cookerly to adjourn the special call meeting. All in favor, say aye.
Aye.
All opposed? All right, that's unanimous. Does anybody need to take a break real quick? All right.
Mayor, can we just take 2?
Yep, 2-minute break.
That was you that Mayor, before we get started, Steve Krokoff, I'd like to double check and see if you can hear me on Zoom. One more time, quick check for sound check for Zoom. One moment, I just want to see if I can get them and then we won't hold up any
That's
longer.
fine.
Much as there, though.
Steve, just double checking Zoom if you're on. Okay, so we'll check it before I'll keep checking in just a few minutes, okay? We're going to go ahead and get started. You got everything live?
All right, we good?
Yes. Mayor,
Okay.
we are good. Let me shift gears.
All right, I would like to welcome Billy Lowe, who will lead us in tonight's invocation.
All right, let us pray. Father, thank you for these sacrificial leaders that come to govern this city. Lord, we pray that you would give them godly wisdom, that as they make decisions and as they have discernment and hear discussion tonight, that you would give them a unity that would help our city continue to flourish as it has. And Lord, as I look around and see the police officers here and the firefighters, we thank you for them too. And we ask that you protect them. And we're grateful for their service, grateful for the promotions that are going to be taking place tonight. And I ask that you would continue to make this place flourish. So we give you all the praise and the honor, and we're thankful for all that you're doing in our lives. We pray all this in Jesus' name. Amen.
Amen. Thank you.
Amen.
I would like to call the regular meeting of the Milton City Council for Wednesday, January 17th, 2024 to order. The city strongly recommends that you review tonight's agenda carefully, and if you wish to speak on any item on the agenda, then please bring your comment cards to the clerk as soon as possible. While the Milton rules allow a speaker to turn in their comment card up until the clerk calls the agenda item, once the agenda item is called, no more comment cards can be accepted. Will the city clerk please call the roll and make general announcements?
Good evening, Mayor and Council. Before I call roll for the January 17th, 2024 regular meeting, I would like to remind those in attendance to please silence all cell phones at this time. Those attending the meeting who would like to make a public comment, you are required to complete a public comment card prior to the agenda item being called. All speakers will identify themselves by name, address, and/or organization before beginning their comment. If you are representing an organization, a notarized affidavit is required stating you have the authority to speak on behalf of that organization. Please review tonight's agenda, and if you would like to make a public comment, please bring your comment cards to me now. Demonstration of any sort within the chamber is prohibited. Please refrain from any applause, cheering, booing, outburst, or dialogue with any person speaking. Anyone in violation will be asked to leave. Mayor and Council, as I call roll this evening, please confirm your attendance. Mayor Peyton Jamison.
Here.
Councilmember Andrea Bierhoff.
Here.
Councilmember Doug Haney.
Here.
Councilmember Juliet Johnson.
Here.
Councilmember Carol Cookerly.
Here.
Councilmember Jan Jacobus.
Present.
And Councilmember Phil Kramer.
Here.
Mayor, you have a quorum. Would everyone please rise for the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, next is the approval of the meeting agenda. Council, I have two changes to make. I would like to move the new business items, agenda item number 24-031 and agenda item 24-032 to immediately follow the consent agenda. And those are the only changes. I'll open it for a motion.
Mr. Mayor, make a motion that we move agenda items 24-031, 24-032 to immediately before the consent agenda.
Second.
Okay, I have a motion from Councilmember Cookerly and a second from Councilmember Johnson to approve the meeting agenda as amended. All in favor, please say aye.
Aye.
Any opposed? That is unanimous. Okay, next is general public comment. Do we have any general public
I
comment?
do not, Mayor.
Okay, I'll waive public comment and I will ask you to call the next item.
Mayor, that item is going to be the reading of the consent agenda. That first item is approval of the January 3rd, 2024 regular city council meeting minutes. Agenda item number 24023. B is approval of the financial statements and investment report for period ending November 30th, 2023. Agenda item number 24024. C is approval of a services agreement between the City of Milton and AKA Tree Services LLC to remove trees from Milton Fire Station 42 for safety purposes. Agenda item number 24025. Our final consent agenda item is D, approval of a services agreement with Coolmere Home Services, Inc., doing business as CertaPro Painters of Alpharetta and Kennesaw for the exterior painting of Fire Station 43. Agenda item number 24026. Mayor Jamison?
Thank you. Do I have a motion to approve the consent agenda?
Mr. Mayor, make a motion to approve the consent agenda as read.
Second.
Okay, I have a motion from Councilor Jacobus and a second from Councilor Verhoff to approve the consent agenda as read. All in favor, please say aye.
Aye.
Any opposed? That is unanimous. Okay, moving on to the new business items. Will the city clerk please say on the first item?
Mayor, that first item is the consideration of a resolution appointing the chief judge of the municipal court for the city of Milton, Georgia, pursuant to Article 5 of the city charter. It is agenda item number 24031. Mayor Jamison?
Thank you. Council, it is my honor to nominate Keith Carnicel as our chief judge. He currently serves as our associate judge, and I'm going to read a little bit about Judge Carnicel and what he has done, not only his professional career, but also what he's done for Milton. Keith A. Carnicel is an experienced litigation attorney practicing throughout Georgia, an honors graduate of Duke University and Emory University School of Law. He began his legal career as a state prosecutor. He worked initially in the DeKalb County Solicitor General's office and thereafter in the DeKalb County District Attorney's office, specializing in high-risk victim crime cases, large-scale drug prosecutions, and asset forfeitures. He worked as a prosecuting attorney for more than 7 years. Thereafter, he went into private practice where he handles a wide variety of criminal defense and plaintiff litigation matters in state and federal court. For the past 2 years, he has sat as an associate judge for the City of Milton Municipal Court. Keith, his wife, and their 2 sons have lived in North Fulton for the past 18 years, and they enjoy spending lots of time at ball fields and parks throughout the area. And I will tell you, Keith has done a fantastic job as serving as associate judge. Like I said, unfortunately, sometimes our citizens' first interaction with the city is at the court system, and I think he will continue on serving as a great chief judge. So that is my nomination. And with that, I will open it for a motion.
Mr. Mayor, make a motion that we approve Judge Carnicel for the position as our chief judge.
Second.
Okay, I have a motion from Councilmember Cookerly and a second from Councilmember Johnson or Councilmember Jacobus to approve agenda item number 24-031. Any discussion on the motion? All in favor, please say aye. Aye. Any opposed? That's unanimous. Come up and take the oath.
Congratulations.
Yeah, thank you.
I, Keith Carnicel, do solemnly swear. I will honestly and faithfully discharge the duties. Judge of the municipal court for the city of Milton. For the ensuing term. To the best of my ability. Without fear, favor, or partiality. We want to do the.
Yes, you guys, just, yeah, you guys scoot over. You're good up there. Everyone's good up there. 2, 1, great. I'm good. Now, family, come on up. Come on. Sure. Judge, you just have to be in the middle. When you get on that side? Or that one, yeah. Yeah, that works too. Here, you look at him first. Now, one right here. 3, 2. I'm good. Are you good? Okay, thank you.
Thank you.
Thank you.
Yeah, thank you.
Okay, will the city clerk please sound the next item?
Mayor, that next item is consideration of a resolution appointing or reappointing members to the City of Design Review Board by appointing a board member for District 1, Post 1. It is agenda item number 24032. Mayor Jameson?
Okay, I'll turn this over to Councilmember Burhoff.
Thank you. I would like to nominate Samia Coker. She is a dedicated registered architect and partner at RLR. She holds a pivotal role in the firm's management, focusing on commercial and retail projects. With her professional credentials extending across 8 states, her design influence resonates throughout the southeastern region. With over 15 years of industry experience, she has cultivated an unwavering commitment to client satisfaction, consistently translating her visions into tangible projects. Samia is an avid participant in the International Council of Shopping Centers. She remains at the forefront of marketplace industry advancements. Additionally, she actively contributes to CREW, the Commercial Real Estate for Women, where she serves on the programs committee, fostering professional connections and supporting women in the field. Samia's collegiate journey started on the soccer fields of the University of Southern Miss, eventually leading her to Atlanta for further academic pursuits after graduation. Alongside her husband, she proudly calls Milton home for a decade. Together, they nurture 3 energetic boys, all passionate about multiple sports, and in her leisure hours, you'll often find her enthusiastically cheering on her kids from the ballpark or their gym. She is looking forward to serving on the Milton Design Review Board, and I know she will make a positive impact immediately. Thank you for your willingness to serve Milton.
Thank you. With Councilmember Burhoff's nomination, I will open it for a motion.
I'll make a motion to appoint Samia, last name Coker, to the Milton Design Review Board.
Okay, I have a motion from Councilmember Haney, a second from Councilmember Johnson to approve agenda item number 24-032. All in favor, please say aye.
Aye.
Any opposed? That is unanimous.
Well, let me get you stationed so he can get pictures. And Mayor, if you can just back up just a little bit. There we go.
I do solemnly swear and affirm I will faithfully perform the duties of the Design Review Board member of this city. I will support and defend the charter thereof, as well as the Constitution, laws of the state of Georgia, United States of America.
Thank you, Sammy. It's nice to meet you.
Yeah. Come on down, because some steps in.
Yeah, all 8.
Congratulations.
You're going to be here after the pins.
Thanks. Let's see. 3, 2, 1. Perfect. Thank you.
Okay. We will move on to reports and presentations. Will the city clerk please sound the items?
Mayor, this next item is one of my favorites. It's recognition and presentation of the City of Milton employee 5, 10, and 15-year anniversary pins. Mayor Jameson?
Was one of my favorites also. This is one of those times of the year where we recognize our employees who have been here for 5, 10, and even 15 years. They have dedicated a large part of their lives on serving this city and making us look good. Day in and day out, they continue to exemplify what we as the council from day one love about Milton, and they make it very, very special place to live here. And I want to say thank you from the bottom of my heart for making us look good. So with that, we are going to honor y'all in your 5, 10, and 15-year pins. Our city clerk will call your names, and we'll kind of get a picture of the group of the 5-year, the 10-year, and the 15-year. So round of applause for them.
There may be a few people missing tonight, but as I call your name, please come down to the podium or here to the dais to greet the mayor. I'd like to recognize Jeffrey Bardagon, Nicholas Godfrey, Laura Hamby, Jean Kemp, Ivo Pereira Jr., Mark Schulte, and Rebecca Tidwell.
Actually, you know what? Can you scoot over this way? There we go. Perfect. Okay. Ready? 3, 2, 1. Okay.
In recognition of our 10-year anniversary pins, with Community Development, Bob Buscemi, Fire, Thomas Dutton, our IT Department, David Frizzell, Police, Scott Lappin, and Fire, Scott Richardson.
Really? You guys are even. Yeah, we're good. Just making sure. 3, 2, 1. Perfect. You can wait. Let's leave it there. Too early.
Well done, gentlemen.
And our 15-year anniversary pins, I'd like to recognize with Police, Kevin Berry. And the rest with Fire are going to be Dana Braden, James Campbell, Joe Champion, Alex Fortner, Andrew Kennedy, and Timothy Murray.
You're a fire you don't know about?
Yeah.
Last year was big. Last year was big. Yeah.
Yes. Yeah. Up here. 3, 2, 1. Good.
Thank you.
Not so much as last time.
Okay, will the city clerk please stay on the next item?
Mayor, that next item is going to be the Finance Strategic Plan Update.
Good
Ms.
evening.
Bernadette Harville.
Good evening, Mayor and Council. Karen had a last-minute emergency she had to attend to, so I will be presenting on her behalf this evening. This is Finance's second strategic plan update. As a reminder, the department has 13 total projects that are involved in the strategic plan. 3 of these have been completed. 1 is currently active, and of 9 of them, Finance plays a supporting role. Those are on some of the land use, sustainability, and economic development projects under the comprehensive plan. Those projects are reported by the lead department, so tonight we will not be addressing those, but just wanted to let you know that they are engaged in those 9 projects. Of the 3 completed projects, the first one we'd like to discuss this evening was the establishment of a financial metrics comparison with like cities. We have been tracking and presenting those measures to you annually during the budget presentation process. Those include revenues and expenditures, as well as current debt limits. And those reports are also housed on the city's ClearGov Financial Transparency Portal on the Dashboards tab. And it's at the bottom of the Financial Stability Dashboard. So you can kind of see every year after we complete our annual audit, we go out there and update it for another year. So right now we have it FY18 through FY22, and 23 will be added around April. So you can kind of see how we compare those categories to our North Fulton cities. The second complete project was the development of a 5-year operational budget to accompany the 7-year capital improvement plan. Staff maintained an informal long-term plan prior to this objective being outlined in the strategic plan, but this officially created a 5-year plan that is now part of our published budget book. The image over here is for the 5-year plan that was published in fiscal year 23, and the updated plan can be found in the fiscal year 2024 budget beginning on page 186. And we also go through explanations of how we come up with our forecasts and what's included and any material changes. We discuss that as well. The third complete project was to track the percentage of revenues across categories with the goal of reducing the reliance on property tax-related revenues. Beginning on page 43 of our current budget book, you can see the current status of every strategic plan outcome measure, including this one. So it'll show you how we are trending and how we are currently by 1% coming down off of that reliance. And we're looking to aim to continue to increase the reliance or our other taxes, so we have less reliance on those property tax revenues. But we are excited to have, like I said, every outcome measure has a status and a tracking in the budget book this year, so you can keep an eye on that, as well as those dashboards on the ClearGov module. The active project we have is related to the occupational tax process and fee structure updates. These are listed in both the strategic plan and the comprehensive plan. Back in November of 2022, myself, Karen, and Anita Jupin all presented to you, to the previous council, kind of where we stood in comparison to other jurisdictions, what we were looking at, and we talked about how our fee structure, the current way it's laid out, was satisfactory. So we were leaving that as is as of now, unless we hear back from the current council that they'd like to bring that back again. We also distributed a business owner stakeholder survey to kind of see how the business owners felt. We did receive just under 60 responses, and the primary feedback was related to the process, not necessarily the fees. So we got a lot of, let us do it online, let us do it online, let us do it online. So Karen and her team have actually looked into that and have implemented a process where the business owners can go online now and pay for that. And they're also looking to get the forms put through that way as well to make that more streamlined for those business owners. So we did address those concerns that came in. We also conducted internal stakeholder meetings. So we talked to some of our counterparts in community development and fire and police who are also all involved in the process, got their feedback on how they felt it was going, and we implemented certain little things to make sure that internally that we're able to move things in a very streamlined and cohesive manner. So we've addressed that as well. And finally, we talked to some of our local representatives at GMA, as well as someone who used to work for GMA and no longer does, to kind of get some feedback on what was going on. And we did present that back to you with Anita's update on economic development initiatives for the budget process. So that's kind of where we are. It's a little bit of an open project as we're still working on some of those process improvements. And unless we hear anything further on the fee structure, we'll just leave that as is. And that is the strategic plan update for finance. I'll be happy to answer any questions I can.
Any questions for Ms. Bernadette?
No,
No.
Okay,
Okay,
thank you.
thank you.
Thank you.
Yep, thanks.
Okay, we will move on to the first presentation item. So will the city clerk please sound the items?
Mayor, that first item is consideration of an ordinance to amend Appendix A, Parks and Recreation Fees and Other Charges, Chapter 34, Section 24 of the Milton City Code, to revise the fees for the Milton Summer Day Camp. Agenda item number 24027. B is consideration of RZ 23-10, 3475, 3485, 3495 Bethany Bend by Arkin Homes, LLC, Hashim, to rezone from AG1 to R5A to develop 13 single-family homes on 3.133 acres. It is agenda item number 24028. Mayor Jameson?
Thank you. Do I have a motion on the first presentation items?
Mr. Mayor, you want me to do both at one time?
Just, yeah, first
Okay.
presentation.
Mr. Mayor, I make a motion on both first presentation items, agenda item number 24-027.
Approve the presentation.
Approve the presentation items. Agenda item number 24-027 and agenda item number 24-028.
Second.
Okay, I have a motion from Councilmember Cookerly and a second from Councilmember Verhoff to approve the first presentation items as read. All in favor, please say aye.
Aye.
Aye. Any opposed? That is unanimous. We'll move on to the public hearing. Will the city clerk please say on the first item?
That first item is consideration of the issuance of an alcohol beverage license to Hyde Brewing LLC. It's doing business as Hyde Brewing at 3100 Heritage Walk, Suite 102 here in Milton. Agenda item number 24029. Ms. Bernadette Harville.
Good evening again. Hyde Brewing LLC, doing business as Hyde Brewing here in downtown Crabapple. Here you can see the advertisement that was placed in the signage that was placed in front of the future establishment. It was also in the Herald on January 4th and January 11th, satisfying that requirement. They are applying for our first brew pub license to come before council. They're also applying for the resident caterer license as well as the on-premises Sunday sales. Here's their location. As you can see, it's over there next to Community Burger and Aberdeen Steakhouse. They do qualify as a full-service restaurant. That means that 40% of their or more of their gross square footage is dedicated to seating for the restaurant establishment. And they also qualify as an eating establishment, meaning 50% of their total gross food and beverage sales comes from the sale of prepared food and meals. And that's all we have for that one. And if you have any questions about the brew pub, I'll be happy to answer those. I know it's our first one.
Okay, do we have any public comment on this?
We do not, sir.
Okay, I'll close public comment and open it for any council discussion or questions. If none, we'll go for a motion.
Do they have a children's menu?
You're trying to
She
show me a
nods
heart.
yes. Okay, a motion?
I'll make a motion to approve public hearing 9A, agenda item 24-029.
Second.
Okay, I have a motion from Councilmember Haney and a second from Councilmember Johnson to approve agenda item number 24-029. Any discussion? All in favor, please say aye. Aye. Any opposed? That is unanimous.
Thank you.
Thank you, Ms. Bernadette. Will the city clerk please say on the next item?
That next item is consideration of the issuance of an alcohol beverage license to Milton Hospitality Group doing business as Restro La Antoinette at 1935 Heritage Walk, Suite 100 in Milton. Agenda item number 24030. Ms. Bernadette Harville.
All right, this is our second and final alcohol beverage license this evening for Milton Hospitality Group, doing business as La Antoinette. Resto La Antoinette? I took German. That's the best I can do on that one. They're at 1935 Heritage Walk in Suite 100, so they are also down here in downtown Crabapple, where the space formerly occupied by Lagarde. They are applying for consumption on premises of wine, malt beverage, and distilled spirits, including those Sunday sales for the on-premise sales. Bring your own beverage as well as resident caterer. This, you could see here the signage in front of the building, and also it was advertised in the Herald on the 4th and the 11th as well, in compliance. That slide, once it comes up, is going to show you that location again, right here downtown on Heritage Walk. They do meet the full-service restaurant requirement that we just discussed. They're at 59% for seating, and they also meet that 50% sales for the eating establishment. So they are in compliance. I'll be happy to answer any questions.
Okay, do we have any public comment on this?
We do not, sir.
Okay, close public comment. Any questions? If none, we'll have a motion.
Mr. Mayor, I make a motion, we approve agenda item number 24-030.
Second.
Okay, have a motion from Councilmember Cookerly and a second from Councilmember Jacobus to approve agenda item number 24-030. All in favor, say aye. Aye. Any opposed? That is unanimous.
Thank you
Thank
so
you.
much.
Appreciate it. There's no zoning agenda items. Will the city clerk please sound the unfinished business item?
Mayor, that unfinished business item is consideration of letter agreement between the City of Milton and Sheldon and Angela Williams resolving all claims related to Lot 5, 14740 Glen Creek Way, Milton, Georgia. It was under new business at the December 18th, 2023 regular city council meeting and then deferred to tonight's meeting. It is agenda item number 23342. Our city attorney, Mr. Ken Gerard.
Mayor, members of the council, thank you very much. As the clerk correctly noted, I had gone over this with the council at the last meeting, I believe, in 2023. At that time, the council chose to postpone it till today's meeting. Since that time, I have some updates, and just very quickly, as discussed during that meeting, the issue that we're facing arises out of a July 2014 minor plat approval by our then not existing, but then Director of Planning and Community Development that approved a minor plat creating a new lot that reflected the provision of sanitary sewer from Fulton County. And that was in fact not only approved by our planning director, but then that was also placed before the then city council on October 20th of 2014 and approved as well. And so those are sort of, those are done. Those affirmations are completed. At the time, I was bringing you two things. One was a letter agreement with respect to a lease, and one was with respect to a deed restriction to lock down and ensure there was no further proliferation of that sewer. Two things have occurred. Number one, I have received some confirmation today that the new owner has agreed, or appears to have agreed, to go ahead and record the deed restriction without an agreement. And I will also tell you that there has been a conveyance of the property, which was what in fact got Milton in the middle of this, was because of the conveyance that has occurred, and there's already been a closing as I understand it. And therefore my concern with respect to release, to the need for a release, is no more. My point simply is, and I'm sort of relying on the presentation I've already given to the council, that the two reasons that I was bringing this to you, both the deed restriction and the concern about the damages, have now gone away. And I believe, Mr. Mayor, it is appropriate to simply rely upon what I believe was an errant, but nonetheless, not only an errant, but ratified by the council plat approval in 2014. So, Mr. Mayor and members of the council, I know that this, I just don't think there's any action for us to take. And
Okay.
so that's, I would otherwise recommend to you to withdraw. I know we have to have public comment. That's perfectly appropriate, but that is going to be my recommendation, is just withdraw the item, because the reasons that I had for bringing this to you no longer exist.
So would the formal motion be a withdrawal motion or just no action taken?
I would be fine with I would be fine with no action being taken,
Okay.
candidly.
Do we have any public comment?
We do not, sir.
Okay, I'll close public comment. And since there's no action taken, any questions for Ken? Okay, with that, we will, next is new business. Will city clerk please sound the item?
Mayor, that item is the consideration of a resolution to approve the donation of 45 sets of expired turnout gear to the Fire Science Program at Woodstock High School. It's agenda item number 24033. Our Matt Marietta. Our Matt Marietta.
I'm not gonna say what we're all thinking, okay, Matt? Good to see you.
Mustache is new if you haven't seen me.
What we were all
We're all
thinking.
adjusting.
Now I know. Thank
It's
you.
taken a while for my wife to get used to it too. So but she's finally gotten on board. The City of Milton Fire Department formed in May of 2007. Since that time, obviously, every firefighter has some basic gear that we have to get them, including the turnout gear, which includes the jacket and the bunker pants. Those items actually have an expiration date beyond which they're no longer considered safe to be wearing in a environment that's immediately dangerous to life and health. That's actually a 10-year date, so we actually have some gear that's been expired for quite a while at this point. And it's starting to clog up our storage facilities. Coincidentally, the state of Georgia at the high school level has a very active career and technical and agricultural education program. And one of their programs that they have is a fire science program in the high school. Because the gear is expired, we cannot resell that to another fire department. We can't put it out on the market. But it is a tangible asset that we have. And the thought was, and according to what I understand from the city attorney's office, we can donate that gear to another government entity according to state law. And I put out a question to local school boards, or not local school boards, but local programs to see who would be interested. And we had Woodstock High School reach out to us and tell us that they're interested in using that gear for training their high school students. Obviously, they're not putting them in hazmat situations or in burning buildings as part of their high school program, but the ability to learn how to don and doff the gear and do exercises and perform in state competitions and stuff is something that they can use that expired gear for. So rather than just jettison it somehow, we figured this would be a good opportunity to maybe encourage our future firefighters in our immediate area. So the resolution would facilitate that, and I'd be happy to answer any questions that you have.
Any questions for Matt?
No,
No?
that's great.
Sounds
Any-
good.
It's a great use.
Any public comment?
We do not, sir.
Okay, I'll close public comment and I'll open it for a motion.
Mr. Mayor, make a motion that we approve agenda item number 24-033.
Second.
Okay, have a motion from Councilmember Verhoff and a second from Councilmember Haney to approve agenda item number 24-033. All in favor, please say aye.
Aye.
All opposed? Thanks, appreciate it. Thank you. Okay, any council reports? Councilman Jacobus?
Yeah, I just have one thing. It's, some people just don't forget about things, and one of them is active parks. I've had a number of calls in the last couple days, sharing with Phil, that people want to know what we're doing. You know, it's been.
Move your microphone.
Oh, I'm sorry. It's been, 30 days since we said no to Hopewell, but what are we going to do next? And I would certainly like to see us in February have some sessions where we start talking about what are we going to do? What can we do? Because there's a lot of people out there that want to know how we're going to solve the problem we have.
Is Steve on? No. Thought he was.
I am.
Okay.
Yes, we can hear you.
Would you like to update Councilman Jacobus or the rest of council with anything?
I would love to, and I
Since it's not just
apologize
an agenda
because my
item, Ken, can we-
headphones are
can we
not working
discuss
great.
this?
Are you getting
This
any
is simply an
feedback?
update. No action will be taken.
Okay.
This is in response to a council member question. I'm comfortable with it.
Okay. Go, Steve.
Are you getting any feedback from me?
Nope, sound good.
All right, very good. Thank you for the question. So I have been working on this with Mayor Jameson for the last few weeks, trying to determine the best way to move forward. I believe just as of a couple of days ago, we've decided that we are going to move forward, get that committee comprised of members of the three boards we discussed, working and looking at our current inventory of properties and providing them some parameters, perhaps on what we'd be looking for in active park space, and just some things to throw out there to give you an idea. That could be one parcel that could be large enough to house a complex, or potentially multiple parcels that could handle different types of active facilities, such as rectangles for sports that are on rectangular fields, and diamonds for baseball and softball. We plan on getting that moving in short order. In fact, I have been drafting an email for the council's consideration, and perhaps I will be able to get that out by tomorrow.
Steve, and just for the record, all those meetings will be open to the public, correct?
That is my intention, yes, with an opportunity for public input as well.
Okay. All right. Any other council discussion on the item?
And just,
Thank you.
yeah, and just to be clear, the three committees and boards that you're pulling folks from would be Parks and Rec, Equestrian, and
Green
Trails,
space.
or
Green
Green
space.
Space?
Is that right, Steve? Were the three committees?
Correct, with Green Space was the third, though nothing is etched in stone. If the council would like to see something different, we have that opportunity as well.
Okay, thank you.
Thanks.
Okay, any other council reports? Want to acknowledge the scouts being here tonight. Appreciate it, y'all. You picked a good meeting, I believe. You could have been here till midnight if you were here a little while ago. So thank y'all for showing up. Appreciate it. Okay, with that, I'll have a motion to adjourn.
Make a motion to adjourn? Second.
Okay, have a motion from Councilmember Cranmer, a second from Councilmember Jacobus to adjourn. All in favor, say aye.
Aye.
Aye. Any opposed? That's unanimous. Thank you.